It doesn't matter. Listen, I'm not asking you if you like what their offer is.
I know.
Okay. I don't care if you like it or not. It doesn't matter. I just need to know if you understand what it is. Listen, just listen to my questions. Do you understand that? What your options are and what your consequences could be. I just need to know if you understand it. Do you understand?
Yes.
And so go ahead.
I'm sorry, Judge.
Good morning, sir. Are you Donald Cogdill? Are you Donald Cogdill?
Yes, ma'am.
And Mr. Cogdill, can you hear me okay?
Barely.
In cause number 26 DCCR, excuse me, 0005, you're charged with the state jail felony offense of evading arrest or detention with previous convictions, and that's from June 25th of 2025. Your indictment alleges you were previously convicted of evading arrest or detention January 12th of 2015. Then the indictment goes further to allege that you were previously convicted of burglary of a habitation December 22nd of 1993. After that was final, you were convicted of burglary of a habitation November 7th of 1994. And then after that, you were convicted of possession of cocaine with intent to deliver, a first-degree felony, January 30th of 2009. And then after that was final, you were convicted of indecency with a child by exposure, a third-degree felony, September 21st of 2017. What all of that means is that if you go to trial and you're found guilty in this current case, and if at least 2 of those prior offenses are true, that you were convicted, your punishment would be that of a second-degree felony, which is between 2 years and up to 20 years. Do you understand? Do you understand that?
The way he's talking is it's going to be a lot better, worse. I mean, I don't understand.
What do you not understand?
You understand the range of punishment is 2 to 20 years, correct?
I ain't gonna make it that long anyways.
Look, I just need to know if you understand that if you go to trial and you're found guilty, what the consequences could be. And the consequences could be a minimum punishment of 2 years up to 20 years. Do you understand that?
Yes, I understand that part.
Okay. So the state has made an offer. I have here on the tablet a plea bargain rejection that you've signed with Mr. Parker that shows that the offer they've made, if you wanted to enter a plea of guilty, is for an 8-year term in prison. You have every right to reject that and have a jury determine if you're guilty or not and what your punishment is. I just want to make sure you understand what your options are if you want to plead guilty and what your consequences could be if you go to trial. Do you understand all of that?
If I may, the state, based on the facts of the offense itself, the state would be more than willing to cap that at 8 years. He received 15 last time on that evading. So we were actually even going to come to the court with seeking your permission for that 8 based on the facts of the offense. But with everything that he has in his past, the state would certainly be willing, based on the underlying facts, to cap it if they make any difference.
Have y'all talked about that?
No, we haven't talked about a cap.
Why don't y'all go back and talk
Okay.
about it and I'll hold it for a minute.
Thank you.
Sure.
What about the page 4? I'm so sorry for everybody looking screaming.
When you going to inherently to add why 15 cases, remember there's one not fixed. And they don't.
Brandon Benton.
Yes, ma'am.
Okay.
Put it with the.
Oh, gotcha. We are resetting Brandon Bonta.
Oh, yes, no.
Bring that. That's gonna be something.
Mr. Lewis, you have Ephraim Dinkin.
Yes, ma'am.
Morning.
No, probably be
Ephraim.
Good morning. Are you Ephraim Dinkin?
Yes.
And Mr. Lewis, will your client waive the formal reading of the motion?
He would.
Mr. Dinkin, and cause number 19-32080. I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation August 12th of 2019 for aggravated assault, and that was a 5-year deferred probation. Is that correct?
Yes.
This motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation office for the months of September and October of 2023. And is that true or not true?
Yes.
True or not true? Thank you. Count 2 alleges that you failed to never become intoxicated or under the influence of any intoxicating substance, and that you tested positive for alcohol June 19th, July 12th, and August 28th of 2023. And is that true or not true?
True.
Count 3 alleges that you failed to provide verification of entering and successfully completing the anger management program as ordered. Is that true or not true? Count 4 alleges that you are behind in your court assessed fees. Is that true or not true? And then count 5 alleges that you failed to complete the drug rehabilitation orientation program, or the DROP program. Is that true or not true? Did you enter your pleas of true to counts 1 through 5 freely and voluntarily? Did you plead true, but did anybody force you to plead true to those counts? Okay. Did you plead true because
True.
they're actually true?
True.
Okay. I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a cap of 10 years in prison. And so as long as I give you 10 years or less, you understand that you're waiving any right to appeal, correct? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Dinkin is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your case for sentencing, get the probation department to do an updated report, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Lewis, and he'll present it to me on your behalf when we come back. All right? See you back at sentencing. You can go back with the bailiff. See, Mr. Lewis, you've got April Smith.
Yes, ma'am.
April Smith. We're sending the paperwork on that.
What, I have a notation that there's new cases coming. Are those?
Have enough day.
Okay.
Yes, ma'am.
April Smith.
She's right on the CDC side.
Okay, that's fine, because I think she'll probably need to get her over here first for fingerprints. Yeah. Character, Mr. Bynum.
Thought about y'all last night. Did y'all feel the boom? Never felt it.
I was thinking, I never felt this. Okay, let's see. This is.
I don't.
We've got April Smith coming. Oh, there it is. Just popped up. As soon as I said it, of course. Good morning. Are you April Smith? And Mr. Lewis, will your client waive the formal reading of the motion?
She does, Judge.
So it's just open.
It is, Judge, and just to update the court, it's my understanding that Ms. Smith is going to plead not true to counts 1 and 2. Frankly, I don't blame her. I have reached out multiple times today, or the detectives asked them to bring those new cases. I believe I even did so in May, if I'm correct, and I still don't have them. So I don't intend to proceed on them. We're just going to go open to the court on the full range of punishment with the understanding that if for some reason those cases are brought in, I don't intend to proceed on this.
Okay. All right, ma'am. Or Mr. Lewis, will she waive the formal reading of the motion?
She does, Judge.
Ms. Smith, in clause number 19-33472, I have a motion to revoke your community supervision. This shows that you were placed on probation August 3rd of 2020 for the offense of theft of property with previous convictions. And that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct? And then it alleges that you violated your probation. Count 1 alleges that you committed the new offense of theft of property with previous convictions May 1st of 2025 in Jefferson County. And is that true or not true? Count 2 alleges that you committed the new offense of possession of a controlled substance, penalty group 1, May 1st of 2025 in Jefferson County. And is that true or not true? Count 3 alleges that you failed to immediately report to the probation officer your arrest on May 1st of 2025. And is that true or not true?
True.
Count 4 alleges that you possessed a drug, methamphetamine, on May 1st, 2025 in violation of your order. Is that true or not true? Count 5 alleges that you were at a location other than your residence at approximately 1:29 a.m. on May 1st of 2025. And is that true or not true? And then count 6 alleges that you're behind in your court assessed fees as of May 19th, 2025 in the amount of $1,713.16. Is that true or not true? Did you enter your pleas of true to counts 3, 5, and 6 freely and voluntarily? And because those counts are actually true. I have some documents here on the tablet that have your signature on them that the state's marked as exhibit number 1. Y'all have marked off that this is a plea bargain, but it's really not. So I'm going to make that change because.
The only reason I did that is because we had the agreement.
Oh,
the new
No,
cases.
so it's fine.
Okay, so there is an
Right,
agreement,
right.
actually.
There was actually.
Thank you, Mr. Lewis.
And Judge, I'm sorry, I misspoke earlier. The offense dates are in May. We checked after our last setting in January.
Right.
And asked them to file them and they still.
Okay.
Yesterday.
Okay, thank you. So the agreement is that the state is willing to not go forward, or if they do at this time receive those cases, not pursue them. And that's part of that plea agreement, which means no matter what I do within the range of punishment, which is up to 2 years in the state jail prison, you're waiving any right to appeal. You understand? State tenders number 1.
No objection, Judge.
It's admitted. Any evidence that Ms. Smith is not competent?
Noted.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 3, 5, and 6 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. However, I'm going to reset your case for sentencing so the probation department can do an updated report. It'll just give me more information about you, your case, what's been going on, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Lewis. He'll present it to me on your behalf when we come back. Okay? See you back at sentencing.
Thanks.
All right, sir. Again, you're Donald Cogdill.
Yes, ma'am.
Can you hear me okay like this?
Yes.
And will your client waive the formal reading of the indictment?
You will.
Mr. Cogdill, I have to go through that indictment again, even though I already did. In cause number 26, DCCR 0005, you are charged with the state jail felony offense of evading arrest or detention with previous convictions from June 25th of 2025. The indictment alleges you were previously convicted of evading arrest or detention January 12th of 2015. It further alleges that you were convicted of burglary of a habitation, first-degree felony, December 22nd of 1993. After that was final, you were convicted of burglary of a habitation, a first-degree felony, November 7th of 1994. That's enough for a second, if that's okay.
Yes.
Judge. How do you plead to that charge?
How you plead? Guilty?
Guilty.
And are those prior convictions true?
Yes.
Are you pleading guilty and true freely and voluntarily?
Yes.
And did you plead guilty because you actually did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Stuff you signed, I explained to you.
Yes.
Do you understand those documents that you signed with Mr. Parker?
Yes.
And do you understand if I follow the agreement that you made with the district attorney that you will be waiving or giving up any right to appeal? So as long as, and the agreement is for a cap of 8 years in prison, which means you're leaving your punishment up to me. And as long as I give you 8 years or less, you cannot change your mind and appeal later. Do you understand?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
All right. I have to ask everyone that. State tenders number 1.
Objection?
It's admitted. Is there any evidence that Mr. Cogdill is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm going to reset your case so the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we will come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Parker and he will present it to me on your behalf when we come back. All right. I'll see you back at sentencing. You can go back with the bailiff.
Thank you.
Ms. Holmes, you have a Brianne Williams.
Yes, sure. That one, we may not, well, you can read yours.
Brianne Williams.
Oh, her. Good morning.
Good morning.
Rand, it's not, it's contained on here.
Ms. French, this is Brianne Williams. It was a TRN, and now there's a new thing that's popping up about fees and yes, I love that. Good morning. Are you Brianne Deshawn Williams? And this is 18-30512. Ms. Williams has a motion to revoke her probation. What is the announcement?
Your Honor, the district attorney's office is showing she has a case received. It's a 2024 offense date, but it's been received. And it appears she had a previous hearing back in 2024, which I think that offense may have been addressed, but it's just now getting to the DA's office to possibly be indicted.
Okay.
Based on the dates, I would agree with Ms. Holmes that the 11/19/24 admin hearing addressed that.
Okay.
But there have been delays with the lab, so I'm not surprised that it's just coming around. But it is received, and the state would like to have an opportunity to review that once indicted.
All right. So we'll just do one normal reset. That way, obviously, if there's another case, you can get it all taken care of at the same time. Ms. Holmes will get all of that information from Ms. French, and she'll be out there to visit with you, go over what your options are. And then we'll see where we are at that next court date. Okay. All right. Okay. Go back to the bailiff.
Thank you.
I'm going to wait. Dan Whitsitt. Good morning. Are you Dan Whitsitt?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, Your Honor. Or it's a.
I'm sorry, the motion.
Yeah.
Yes, hold on. Let me get that pulled up. Let me get it pulled up real quick. Okay, Mr. Whitsitt, in cause number 24 DCCR 0198, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 1st of 2024 for the third-degree felony offense of injury to a child, elderly, or disabled individual, and that was a 3-year deferred probation that's been extended for 2 years. Is that correct? The motion alleges you violated your probation. Count 1 alleges that you failed to successfully complete the safety program and the aftercare, and that you were removed from it on December 18th of 2025. And is that true or not true?
It's true.
Count 2 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
True.
And then count 3 alleges that you're behind in your court assessed fees. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Whitsitt is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find that you're mentally competent to understand the nature and the consequences of those pleas. Find sufficient evidence to find you guilty, and at this time, find you guilty of the third-degree felony offense of injury to a child, elderly, or disabled individual. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff. Not real sure. I mean, it's set for sentencing, so I'm very confused about what all that meant.
What are you talking about?
Yeah. And we've had her come every single week. You don't get to just write a letter the day of court and say,
And file it after.
and there's a bug. I'm not crazy. Did you see it? Thank you.
I've seen it.
I know. That's for us that day, right? Yeah.
Oh my gosh, it is.
Good morning. You're John Lamel.
Yes, ma'am.
So, Mr. Lamel, I just wanted to visit with you, and so we can hopefully get your case moving forward. I know Mr. Adams has had some issues and has been unable to come to court. He filed a motion to withdraw as your attorney. Do you have any objection to that?
I don't know what you're talking about.
He wants to withdraw and not be your attorney.
Yeah.
Are you okay with that?
Yes, ma'am.
Okay.
They wasn't coming.
Right. And so here's what we can do. I can, because you're in custody, I can appoint an attorney today who can start working on your case. Do you want me to do that? Or do you think that you or your family have money to try to hire someone else?
No, ma'am. You can give me a.
Okay. I will appoint someone today. I will let that attorney know that you've been coming and we've been having some issues and you're just sitting and waiting. And so hopefully they'll get up to speed real quick and we can see what we can get done with your case. Okay.
Thank you so much.
No problem, sir. You can go back with the bailiff. So if you want to print out that order, I'll sign it. I mean, it's a state jail felony MTRP. It's.
You can do it. Oh, yeah, somebody else, he wanted to change.
What did I do?
Oh, I don't know, that's you. Okay. It's just strong.
Maybe. Yeah. Yeah, it's up on the right.
And we think that Mr. Burbank will still be able to maybe come over for that bond hearing. We're just going to kind of hold it until they're finished with closing argument next door. And so let's see, Mark Phillips, Ms. Holmes.
And give the data to side.
And I checked the first allegation. It says a Orange County case. I did check with North County. They said the case has not been filed. They said it's in review.
Okay. All right, so are you Mark Phillips? Mr. Phillips, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. And will your client waive the formal reading of the motion?
Yes, Your Honor.
Mr. Phillips, in clause number 21-36585, I have a motion to revoke your community supervision. Shows that you were placed on probation September 13th of 2021 for the third-degree felony offense of unlawful possession of a firearm by a felon. And that was a 10-year term in prison that was probated for 5 years. Is that correct? It alleges that you violated your probation. Count 1 alleges that you committed the new offense of assault family violence in Orange County on October 3rd of 2025. And is that true or not true? Count 2 alleges that you provided a urine sample August 13th, September 10th, and October 13th of 2025 that tested positive for marijuana. Is that true or not true?
True.
Count 3 alleges that you admitted to your Orange County probation officer that you used marijuana on or about August 27th of 2025. Is that true or not true? Count 4 alleges that you provided a urine sample November 6th of 2025 that tested positive for marijuana. And is that true or not true? Count 5 alleges that you admitted to the use of alcohol on August 27th of 2025 to your probation officer. Is that true or not true? And then count 6 alleges that you failed to prove the attendance of AANA meetings as directed by the substance abuse evaluation. Is that true or not true? So did you enter your pleas of true to counts 2, 3, 4, 5, and 6 freely and voluntarily? And because those counts are actually true. All right, then I'm going to find that you entered your pleas of true to counts 2 through 6 freely and voluntarily, find sufficient evidence to revoke your probation. However, I'm going to reset your case for sentencing, get the probation department to do an updated report that'll give me more information about what's been going on, maybe get some more information about that count 1, the assault case, if the state intends to bring any evidence with regard to that. Well, I would think an 11 o'clock hearing would be enough.
Should be true.
Okay, so we'll set it at 11 o'clock for a hearing on sentencing. All right, go back with the bailiff.
Again.
Oh, sir, she needs your fingerprint, please. Daniel Pierce.
That's a dismissal, Your Honor. That's all, Your Honor.
Oh, got it. Signing that. He's free to go back.
As today's hearing came to an end, the judge made one thing crystal clear: every decision has consequences, and every choice shapes the future. Some defendants were given another chance, while others faced the reality of prison sentences. In the courtroom, respect, responsibility, and accountability always come first. What do you think about today's rulings? Share your opinion in the comments below. If you enjoy real courtroom cases and legal updates, don't forget to like, subscribe, and turn on notifications for more powerful courtroom stories.